Mm, yeah. I like to see it. Sounds good. Aside from, aside from the external stuff, this is exciting. Yeah. Yeah, yeah, right. Yeah, my mom was like, happy to. Yeah, correct, yeah. Yeah. My mom is always like at least 20 to 30 minutes early, so I'm like, thinking that's something. No. Right. Yeah, that's fair. No, yeah, I do mind.
Hello, thank you all for coming. I just ask you if you have your cell phones, that you please silence them or put them away for the duration of the meeting. We are recording it, so it will be videotapes available later if folks need it. And with that, I'm going to turn over the floor to the Honorable Judge Tolman. Thank you.
Retired, so I can't hold anybody in contempt. Good afternoon, friends, guests, relatives. We are here today to celebrate the 1952 decision by Chancellor, hate this thing, Seitz in Beulah and Belton versus Gebhardt. In that case, Chancellor Seitz held that the school facilities between Blacks and whites were inherently unequal and that African-American students should be admitted immediately. That decision followed the decision by Chancellor Seitz in Parker versus University of Delaware, which found that the Black students could be admitted to the University of Delaware since the facilities at then Delaware State College for colored students were not equal. What I would like to do is to give you some basic background and context to the case, to the presentation today. My name is Charles Tolliver. I am, for better or for worse, a native Delawarean and a member of the Delaware Bar since 1975, before most of you were born. And I am, I'm proud to say, a beneficiary of Chancellor Seitz's decision in Belton and Beulah versus Gebhardt. In terms of background, in Delaware, slavery was legal through the Civil War. Delaware did not secede from the Union during the Civil War and did not reject slavery until after its conclusion. Separate but equal was the law of the land, which ultimately was codified by the U.S. Supreme Court in Plessy versus Ferguson. Interestingly enough, the 13th, 14th, and 15th Amendments to the U.S. Constitution were adopted by a requisite number of states after the Civil War, becoming a part of the federal constitutional framework. The 13th Amendment prohibiting slavery was adopted by Congress on December 6, 1865. The 14th Amendment Due process and equal protection, among other rights, was adopted by Congress on July 20th, 1968. And the 15th Amendment, guaranteeing the right to vote shall not be denied, was adopted by Congress on February 3rd. I was going to say 2070, but it'd be a little hard, 1870. Interestingly enough, the state of Delaware did not follow suit until February 12, 1901. In terms of the state of Delaware education, or education in the state of Delaware, it was generally deplorable for all students, black, white, brown, or whatever. But it was much worse for African Americans. The noted philanthropist and businessman P.R.S. DuPont, between 1920 and 1931, at his own expense, built or rehabilitated 90 quote-unquote color schools in all 3 counties. And interestingly enough, his rationale was, I will motivate white hoods and whites to fund school for whites if I build new schools for blacks. In other words, we can't have those coloreds receive better education than the whites, which was an interesting but effective philosophy because education in Delaware did start to improve. During a period of time between 1920 and 31, when Mr. DuPont did his work, Howard High was built. That was in 1928. And the schools, the quote unquote color schools, were determined by number, as all schools were. And to give you an example, Newark School for colored students was designated as 110C. All the schools were designated in that fashion, although the other schools were not designated by number and W or C for Caucasian. The Newark School is now the George Wilson Community Center in Newark. I would also like to note for you that the state of Delaware built William C. Jason High School, which opened in October 1950, and the William M. Henry High School, which opened in September 1952, both before the Bueller/Belton litigation began. The schools were built to serve colored students of lower Delaware, that is Sussex County, that was Jason, and central Delaware, which was Kent County and William Henry. Until those points in times, African-American students who wanted to go to high school had to travel or move to Wilmington and attend Howard High School. It was a common practice for people to board students from the lower 2 counties. Children, no matter where they lived or proximity to a school, could only attend schools set aside for those of his or her race. And I have some historical background. My father and mother, both native Delawareans, were educated in that fashion and graduated from Howard High School in 1938 and 46, respectively. When the litigation began, it was the state of Delaware was represented by H. Albert Young, Attorney General, who in 1959 founded his own law firm, Young, Conaway, Stargett, and Taylor, which ultimately became. The plaintiffs were represented by Lewis L. Redding of Wilmington, assisted by several NAACP national attorneys. Mr. Redding was a native Wilmingtonian. He was the son of a postal worker, and I believe his mother was a domestic, but I'm not exactly sure about that. He graduated from Howard High School in 1919 and Brown University in 1923. He taught for 2 years before gaining admission to Harvard University, from which he graduated with honors in 1928. He was admitted to the Delaware Bar as its first African-American attorney in 1929. He was required to, and did, because we were all required to complete, all attorneys, clerkships. He completed his clerkship at night at the office of his preceptor to avoid public controversy. And I am told the deal was that his father would help deliver votes for a particular candidate if his son got the clerk. Now that's anecdotal. Don't put me under oath or try me for perjury, but that's what I am told. Mr. Redding was the only African-American attorney admitted in the state of Delaware until 1951, when Theophilus Nix Sr. was admitted. In terms of the individual plaintiffs, Sarah Beulah, whose daughter was an elementary school student, was not allowed to ride the school bus, which came past her house and the Hockessin Colored School every day on his way to white schools, which required her mother to make the daily 2-mile drive so that she wouldn't have to walk and could go to school. Ethel Belton, whose daughter, a high school student, had to make a 20-mile round trip daily from Claymont, passing by Claymont High to Wilmington. Both plaintiffs, along with other parents, consulted Mr. Redding, who agreed to take the case and challenge what I term has been termed de jure segregation. It is given this background that Chancellor Seitz was presented with the controversy post his decision in Parker versus University of Delaware. Chancellor Seitz was ahead of his time and had set the framework, and be mindful that he couldn't say separate but equal was wrong, because that was the federal case, which was ultimately overturned in Brown. But what he did was meticulously investigate, research, and determine, which was an interesting process that he went through, to determine that the schools were drastically different, and the African-American schools were very much inferior in terms of teachers, pay, and other resources. And it is also important to note, and again, in this context, that these cases were combined with the other cases nationwide, 5 other cases taken to the U.S. Supreme Court in Brown versus Board of Education. However, I am proud to note that only Chancellor Seitz's decision was affirmed. His was the only one to, in effect, say you can't actually have separate but equal because there will be no equality. He also indicated that it was not appropriate to tell plaintiffs, you have constitutional rights, but you have to wait for the state to remedy it. He said, now, I wish they had used his language instead of with all due deliberate speed in the U.S. Supreme Court decision, which left a whole lot to be desired. You are about to see a reenactment of a portion of the trial in the Belton case that is largely based upon rulings, motions, and actual court transcripts from that action. Playing the role of Mr. Redding is Justice Christopher Griffith, sitting here. Playing the role of Chancellor Seitz as his son, Chief Justice Colin Seitz Jr. Playing the role of expert Kenneth Clark is Wally Rushton, I think. Oh, there he is. I know I saw him. Other attorneys are played by Nick Moselle, Keneal Radisson, Pelasucci. I was close. And Mommy Boateng. I was close there too. Our visuals outside the courtroom were provided by Parcels, and our trial graphics were prepared by Magna Legal Services. I will, as I used to do back in the old days, call this session to order, and I will now ask the bailiff to begin our trial, and I will stop talking. Thank you.
All rise. Hearing. All persons with any business before the Chancellery may now appear and he shall be heard. The Honorable Chancellor Thomas J. Sykes presiding. Court is now in session. Please proceed.
I like that, Chancellor Seitz. All right, so welcome back, everyone. We're going to proceed with the trial. Do we have anything we should address before the plaintiffs call their next witness?
Good afternoon, Your Honor. Camille Radinson Blasucci of the Delaware Attorney General's Office on behalf of defendants. Plaintiffs have indicated they intend to call Dr. Kenneth Clark as an expert witness next. We have already raised and presented our motion in limine at the pretrial conference, and so Your Honor is aware that we believe Dr. Clark's testimony is not relevant to the issues before the court, which are: one, whether the separate facilities offered to African American and white children are equal, and two, whether other factors such as travel and psychological effects of separate but equal facilities are relevant. Your Honor has already visited the schools, and we do not think it is necessary to hear Dr. Clark's testimony to compare the schools. Most importantly, Dr. Clark's proposed testimony is not relevant because, as a legal matter, this court is bound by the United States Supreme Court decision in Plessy v. Ferguson. But even if Dr. Clark's proposed testimony was relevant, it should still be excluded because his research on the psychological effect segregated schools have on African American children is flawed in a number of ways, as described in our papers. Defendants therefore renew our motion and ask that Dr. Clark not be permitted to testify and that his report be excluded from the record.
All right, so you would like me to exclude his testimony and his expert report from the record, is that right?
Yes, Your Honor.
Okay, would the plaintiffs like to respond?
Thank you, Your Honor. Mame Boateng on behalf of the plaintiffs. Your Honor already dealt with this, and nothing has happened so far during trial to warrant revisiting your decision from the pretrial conference. Dr. Clark has previously testified as an expert in similar cases, and his work here easily satisfies the relevant standards. That is particularly true, given this is a bench trial where Your Honor is being asked to analyze the evidence. The practice in this court is for Your Honor to hear from the experts and then give their testimony the weight it deserves, rather than exclude it entirely. The quality of the facilities, the travel required, and the psychological impacts are all relevant to whether my clients are in fact receiving equal education. And Plessy is irrelevant because we've requested relief on the basis that the separate facilities and educational opportunities offered to the plaintiffs are not equal to those made available to white children similarly situated.
Thank you very much, counsel, for the arguments to exclude Dr. Clark's testimony and report. I'm going to deny the motion. Given the party's focus on it, I've already read Dr. Clark's report. It first discusses whether the facilities and educational opportunities offered to African American children are equal to those offered to white children as it relates to class size, courses offered, extracurricular activities. I've heard evidence from both sides about this, and Dr. Clark will remain subject to cross-examination, and the court will need to decide how to weigh his opinion against the evidence. Dr. Clark's report speaks directly to the mental health of African Americans, and therefore whether their educational opportunities are adversely affected by state-imposed segregation in education. His opinions are based on unchallenged facts, and he uses tests and methods that are accepted for comparing the quality of education. And it is plainly relevant, in my opinion, and helpful for me as the fact finder to understand these impacts of the current educational system. He appears to be one of America's foremost psychiatrists. So let's get to the evidence and hear from Dr. Clark. Mr. Reddy.
May it please the court. Louis L. Redding here on behalf of the plaintiffs. At this time, Your Honor, the plaintiffs wish to call their final witness, Dr. Clark, to the stand.
Please take the stand.
Please state your full name for the record.
Dr. Kenneth Clark. Could you please pull the microphone in front of you? Dr. Kenneth Clark.
Thank you very much. Dr. Clark, what is your current occupation?
I'm a practicing psychologist and an educator.
Where do you work?
Currently, I work for the City College of New York as a professor.
Are you a tenured professor?
Yes, I am.
How long have you been teaching as a psychologist?
Approximately 13 years.
And are you still licensed and practicing psychology?
Yes, I'm currently practicing in the state of New York.
Could you discuss your educational background for the court, please?
Certainly. So I received my bachelor's degree in political science from Howard University in Washington, D.C. From there, I pursued a master's degree in psychology also at Howard University. I went on to matriculate at Columbia University, where I pursued a doctoral degree in psychology.
Did you write a thesis during your graduate studies?
Yes, I did.
And what is the title of that thesis?
The title of my thesis was The Development of Consciousness of Self in the Emergence of Racial Identification in Negro Preschool Children.
And what is this thesis about?
Penny Reading is essentially a study of 150 Black children from segregated nursery schools to understand the development of self-perception and race consciousness in children. 50% of the participants in the study were girls and 50% of the participants were boys.
What did you conclude from your study?
Several conclusions were arrived. The first was that self-perception related to race begins at a young age. Secondly, I concluded that children as early as 5 years old begin to reach a self-awareness and now see themselves in an intrinsic way and are less capable of external representations.
Did you use that thesis as a basis for some of your expert opinions, which we'll discuss today?
Yes, I did.
Have you ever been admitted as an expert witness before?
Yes.
Have you ever testified in court about the effects of segregation in education?
Yes, I have, in a similar desegregation case in South Carolina that's currently pending.
Have you ever conducted any tests or experiments about the effects segregation in education?
Yes, it's called the Dow test. The test in terms of its subjects has varied up to 250 students. And it's the same test that I use for the students here in Wilmington as well.
Did you partner with anyone in conducting your study?
Yes, my wife, Mamie Phipps Clark.
Could you please provide the court with some background about the doll study?
It's essentially a test that I've used extensively with Black children from the very young through the adolescent period, utilizing questions about white and Black dolls as a means to measure the psychological effects of segregation on Black children.
Has the doll test ever been used before to evaluate the effects of state-imposed segregation?
It is not. The Dow test experiment has never been conducted before my implementation of it, but it cannot be viewed in isolation. The Dow test and other data that I have collected clearly show that segregation has a negative effect on Black children.
Could you now please summarize how you conducted the doll study?
So the dolls that were utilized came from exactly the same mold and were identical in every respect, except for their skin color. These dolls did not have any clothing on them and were presented to each child on a table without any clothing. I would then ask the children a number of questions once the dolls were presented to them. The questions were designed to test whether the child understood the meaning of the racial factor as indicated by the color of these dolls. Simple questions I would pose, such as, which is the colored doll? Which doll is the Black doll? Because I don't have an understanding of this. And why is it the Black or white doll? Once I determine whether the child associated a racial factor with the color of these dolls, I then ask the child a number of questions to determine his or her preferences or his or her feelings about these dolls. For younger children, I would ask a simple question such as, which one do you like the best? Which one is the nice doll? And which one looks bad? For the older children, and particularly the children in the city of Wilmington, I modified the questions by asking, which one would look nicer in clothes? Or which doll is the one that may act bad? Or show me the doll which has the nice color. The experiment has consistently showed a clear preference for the white doll among the children in the studies I've conducted across multiple geographic areas.
Dr. Clark, did you put together a video that summarizes the doll test that you and Mrs. Clark conducted?
Yes.
Will we please play the video for the court?
Which doll is the black doll?
Yes.
And which one is the white doll?
That one.
Which doll is the pretty doll? Which doll is the nice doll? Which doll is the bad doll? Which doll is the nice doll? Which doll is the bad doll? And why is that doll pretty?
Because he's white and he has 2 eyes.
Which doll is the ugly doll? Why is that doll ugly?
Because he's black.
Which doll looks most like you?
Like me.
Yeah, which one looks like you?
And that one.
Okay.
That doll.
Dr. Clark, you mentioned that you conducted this test here in Wilmington. How many students took part in the test?
I interviewed approximately 40, well, exactly 41 students for this test.
And what were the results?
Each of the students, each and every student identified themselves with the black doll, firstly. And 75% of them associated that doll with the negative stereotypes and bad behaviors that I've discussed.
What did you conclude from these tests that you've conducted?
Well, first, that the practice of segregation as perceived by these youngsters impaired their general functioning as revealed by the results of these tests and the results of my interviews with them. The nature of that impairment seems clearly indicated by the results in which it is seen that 3 out of the 4 youngsters, when asked the question, which of these dolls is likely to act bad, picked the brown doll. The brown doll to them was associated with all the negative stereotypes which are usually ascribed to Blacks in our culture. This indicated clearly the damage to self-esteem of these youngsters. So when you see that 100% of these youngsters correctly identified themselves with the brown doll, and 3 out of 4 of them had made a choice of one of these dolls when asked, which one is likely to act bad? A question which sounds almost innocuous or silly, but which nevertheless pulled this response from these youngsters. I think we have clear-cut evidence of rather deep damage to self-esteem of these youngsters, a feeling of inferiority, a feeling of inadequacy, evidence which was further supported by the kind of things which the youngsters said, such as, I suppose we do kind of act bad, or we don't act like white people.
In addition to the video, did you prepare a report that summarizes your expert opinion?
Yes, I prepared 2 reports, the doll test report and the racial identification and preference in Negro children report.
In a nutshell, could you please summarize your expert opinion?
Yes, Attorney Redding. So segregation of white and Black children in public schools has a detrimental effect upon Black children. When you put a Black child in a segregated school, it generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way that may never be undone. This finding seems to me to be unquestionably clear from the evidence and the entire literature available. A survey of the opinion of social scientists, psychologists, anthropologists, and sociologists shows that 90% of them state unequivocally that segregation is detrimental to the personality development of the individuals who are the victims of the segregation. They state the specific ways in which the detriment exists. Furthermore, 83% of them maintain that the patterns of segregation are detrimental to the personality development in a different way on those individuals who actually enforce the segregation. In some, school segregation imposes adverse psychological impacts on the victims of the segregation and those that actually enforce it.
Thank you, Dr. Clark. In addition to the DAL tests, what other facts and data did you consider informing your expert opinion?
I also visited Delaware school systems for Black and white children. The Claymont School, which is a school for white children, the Howard High School, which is a school for Black children, and the Carver Vocational School, which is a vocational school for Black children. Now, Howard and Carver operate administratively under the same principle, and the respective buildings are connected via a breezeway. So due to these similarities, I may refer to the schools throughout this proceeding as Howard Carver, unless otherwise indicated.
What sort of examination did you conduct at each school?
So I looked at 4 distinct areas. The first was school transportation. I also examined the building's facilities and their aesthetics. I examined the student to teacher ratios within each school. And lastly, the class sizes for each major academic subject.
When did you conduct your study?
Between October 2nd and October 12th, 1951.
And what did you conclude upon collecting the data?
I came to 3 main conclusions, Mr. Redding. The first was that Howard Carver offers educational opportunities that are substantially inferior to Claymont High School. Secondly, that segregation itself results in Blacks receiving inferior educational opportunities, and a separate but equal approach to public education creates an unsolvable conflict that seriously interferes with the mental health of children.
Let me focus your attention on school transportation. What differences, if any, did you find between Claymont High School and Howard High School with respect to school transportation?
The transportation circumstances of Ethel Louise Belton are representative of the issues here. So as you can see here on the screen, Claymont High School is 1.5 miles from the home of Ethel Louise Belton. It's approximately a 5-minute commute from her home. By contrast, Howard High, where Ethel Louise Belton is required to attend, is 9 miles away and is 50 minutes from her home. School buses are not available for Miss Belton, and she is therefore required to take public transportation to and from school. Now, a student has an 8-hour block of key value time each day. For Ethel Louise Belton, daily travel time to and from school consumes about 25% of her most valuable block of time, as you can see depicted on the left bar. If Ethel Louise Belton were permitted to walk to Claymont High School, she would have, for other use, an extra half hour each afternoon, plus extra time in the morning, otherwise spent in travel. Now, it's easy to appreciate this on a daily basis, but when you aggregate this over the course of a school year, this amounts to 132 hours over the course of a school year that she's losing to travel time. My conclusion from this data is that travel to school increases fatigue and irritability in school children, thereby impairing the learning process, exacerbating the already detrimental psychological effects of segregation that we've discussed.
Thank you, Dr. Clark. Let's talk about the facilities at the 2 schools, Claymont High School and Howard High School. What were your observations on a comparative basis as to the physical buildings and aesthetics of these 2 schools? Let's start with Carver.
So Attorney Redding, on the screen here, you see a visual floor plan of the Carver School. As I mentioned previously, it's part of the Howard administration. It's a very old building without an auditorium, library, or gymnasium, or regular cafeteria. It has a makeshift cafeteria, in fact, in a dingy basement, and has neither seats nor tables for the children to eat their food. It has one lavatory for both boys and girls on an unsanitary cement floor. Students that are traveling from Howard to Carver to attend the VOTEC school are not protected from the weather in that breezeway that I mentioned. Furthermore, the school is located in a congested area with no land in front or the rear for play space for the children.
And as to Howard,
Yes, so this is a floor plan of Howard High School. The building itself is in fairly good condition. It's built on a 3.5 acre site. However, the building does have, the overall grounds have an adequate play space for the children. And the building itself is flanked by industrial buildings and poor and substandard housing on all sides. The facilities have no gym, and the students, in order to have gym activities, have to go to a few blocks down the road to the local YMCA. There's also no cafeteria in Howard High School. And as I mentioned previously, the condition of the Carver cafeteria, that's in fact what the students at Howard use, a basement location with no chairs and no tables. The building does have one library and one assembly room.
and let's go to the Claymont High School next.
So you see here a visual of Claymont High School. It's a very attractive, aesthetically speaking. It has beautiful landscaping. It's located on a 14-acre site. There's ample room for playground and related equipment, as well as for the implementation of sports of almost any character. The building itself features 2 floors. We'll start with the second floor, in which there's a gym, an auditorium, a cafeteria, and laboratory facilities for boys and girls. The first floor of the facility features a library, an art room, a health room, a science lab, and additional laboratory facilities for the girls and boys.
And what did you conclude upon your review of the schools?
My conclusion was that Claymont's facilities are both aesthetically and functionally superior. Students whose classroom environment is less desirable than other classroom environments may be expected to be adversely affected by such conditions, so that in the end, they might not achieve as much.
Did you make any investigation as to the relationship of class size to the number of teachers at both schools?
Yes, I did. There's a 25-to-1 ratio that's been fixed by the state educational authorities as a desirable maximum. However, many more of the classrooms at Howard Carver exceed the 25-to-1 student-teacher ratio than at the Claymont High School. I looked at the class size in 8 academic subjects: foreign language, math, physical education, home economics, industrial arts, natural sciences, social studies, and English. In 6 of those academic subjects, there were larger class enrollments at Howard than at Claymont. At Howard, the average teacher carries a teaching load of 178 pupils per week. At Claymont, the average teacher carries a teaching load of 149 pupils per week. As this slide indicates here, this is a visual representation of this disparity, and the disparity only exacerbates further with time. Thus, teachers at Howard carry an average teaching load of 29 more students, which by way of implication that the teacher does not have as much time to handle individual differences amongst the school children. In other words, a teacher with 25 students has a far easier job than a teacher with 54 pupils. It also means a difference in the amount of time that a student may participate in a class and therefore learn from that participation. It means the difference in the amount of work wherein the total load of the teacher is considered in grading papers and evaluating notebooks and other issues in all of the important aspects of a teaching situation. The disparities in this regard can be appreciated both by education professionals and laymen. Thus, students enrolled in a smaller class have a better educational opportunity.
Based on this, is it easy to conclude that students enrolled in the smaller classes at Claymont receive a better education?
Absolutely.
How do we tie all this together, Doctor? What's the correlation between the DAL test and the data you've collected about the schools?
Attorney Redding, I'd make 3 points on this. The first is that legally enforced segregation in education, in and of itself, prevents Black children from receiving opportunities which are equal to white children. Segregation, as shown by the DAL test, also generates a feeling of inferiority in Black children as to their status in the community that may affect their hearts and minds in a way that may unlikely ever be undone. Additionally, the educational facilities and opportunities at Claymont High School are far superior to the educational opportunities and facilities at Howard Carver High School. In short, there is nothing equal about the separate school facilities that Delaware currently offers.
Thank you, Dr. Clark. No further questions.
Cross-examination.
Good afternoon again, Your Honor. Nick Moselle on behalf of the Delaware Attorney General. Professor, you worked on your thesis with your wife, correct?
Yes.
And you had no other co-authors, correct?
No.
You and your wife invented the DAL test, correct?
That's correct.
No one had ever conducted it before you, correct?
That is correct.
And all of the results that you were reporting about in this case derive from techniques that you and your wife created, correct?
Yes, that's correct.
And your report cites no other publications or studies in relation to the procedures that you selected for use, correct?
Yeah. Yes.
The study in your master's thesis was limited to 150 students, correct?
That study was limited to children from segregated Washington, D.C. nursery schools.
That study did not focus on public elementary or secondary schools, correct?
Correct.
In the group that you administered the test to at Howard High School, there were some of the individuals were plaintiffs in this case, correct?
There were some who were and some who were not.
And in the group that you administered the test to at the YMCA, some of those individuals are plaintiffs in this lawsuit as well, correct?
That's my understanding, but I have no absolute way of checking that.
But the fact that that these individuals were interested in the proceedings, that could affect how they participated in the tests, correct?
It's a possibility. And that's one of the reasons that in attempting to interpret the results here and attempting to see whether the results are valid, we would be sure to have both non-plaintiff as well as plaintiffs. And if you would like, I'm happy to present a breakdown of the data relating to those two groups.
Thank you. That won't be necessary, but we will focus on Howard and Claymont High School for a few minutes. Professor, you would agree with me that the college preparatory curriculum at Howard High School is adequate for the admission to many colleges, correct?
Correct.
And when you calculated your student-teacher ratios, you used the figures of 1,274 pupils and 53 teachers for Howard, correct?
Yes, that's correct.
And that led to a student-teacher ratio of about 24-1, correct?
Correct.
Now for Claymont, you used 800 students and 22 teachers, correct?
Yes, and I know where you're going, so I will just address it. Not all 800 of those students are high school students, whereas all of the students at Howard are high school students.
Thank you for cutting to the chase, Professor. Would you agree with me that in calculating the student-teacher ratios that we were discussing, you compared different numbers, correct?
Yes, but it doesn't change my conclusions as to the adequacy of the student-teacher ratios at those schools.
Both the Howard and Claymont schools have student government organizations, correct?
Yes.
And you did not attempt to compare the participation in those organizations between the two schools, correct?
Correct, I did not.
Howard High School has the larger library as compared to Claymont, correct?
Well, yes, but you would assume that given that it is the larger of the two schools.
You found both libraries at Howard and Claymont respectively to be very satisfactory, correct?
I believe that's what I said, yes.
You believe that both schools are well equipped, correct?
Yes,
You spoke earlier about the physical appearances of the schools. Do you recall that?
I do recall that.
Now, Wilmington High School is the closest high school to Howard High School, correct?
That's my understanding.
And you did not have occasion to see or visit Wilmington High School to be able to compare it, correct?
Well, I visited Wilmington High School after issuing my report.
So to be clear, at the time you prepared your report for this case, you had not visited Wilmington High School, correct?
That is correct.
You have not interviewed any students at Howard who told you there were courses or subjects they wanted that were offered at Claymont, correct?
Correct.
In your review, you determined that the money the state allocates to both Howard and Claymont is equal. Isn't that right?
That's correct, but it doesn't address that number of other factors, such as that schools operate under different administration and school boards. So it doesn't accurately address the issue of total funding.
Regardless of the source of the funding, Professor, the average salary for a teacher at Howard High School is higher than the average salary for a teacher at Claymont. Would you agree with me?
Yes,
And you did not try to determine whether there's been an attempt to have teachers with formal or better education in greater numbers at Claymont as compared to Howard, correct?
that is correct.
And you would agree that the method of instruction is roughly the same in both schools, correct?
Correct.
Both schools are modern in their approach to teaching methods, correct?
Yes, but the resources disparities.
Yes, Professor, the answer is yes or no. I appreciate it. No further questions, Your Honor.
Any redirect?
Yes, Your Honor, very briefly. Dr. Clark, what were you trying to say about the resource disparity?
Thank you, Mr. Redding. What I wanted to say is that the stigma associated with segregated education that I discussed earlier so adversely impacts the psychology of Black children that it cannot be cured by virtue of a common teaching methodology. Further, the inadequacy and disparity of resources amongst the schools that I have discussed, including but not limited to the inferior facilities, the larger class sizes that characterize the Howard Carver School versus the Claymont School, are systemic issues that even the most committed teachers using the best methods cannot cure themselves.
Thank you, Dr. Clark. No further questions.
Thank you very much. And thank you, Dr. Clark. You may step down. So as Judge Tolliver so eloquently told you before the testimony, my father, Collins J. Seitz, presided over the 1952 cases leading to the desegregation of the Hockessin and Claymont public schools. A little about my father. My father was a judge for over 50 years, first on the Delaware Court of Chancery and then as a federal judge on the United States Court of Appeals for the Third Circuit, where he also served as the chief judge. He grew up in a family that struggled through the Great Depression when his father died, leaving his mother to raise her 5 children. Being the youngest of 5 children, my father always said it qualified him for underdog status. His hardscrabble upbringing and innate sense of fairness and right and wrong eventually led him to public service as a vice chancellor on the Court of Chancery. In the late 1940s and early 1950s, the Delaware Constitution, as Judge Tolliver told you, and state law required segregated educational institutions. Blacks and whites could not marry. Delaware was, as my father remarked, a northern state with a southern exposure. The U.S. Supreme Court's decision in Plessy versus Ferguson was the law of the land. Under Plessy, as Judge Tolliver explained, the Equal Protection Clause of the United States Constitution, according to the U.S. Supreme Court, sanctioned separate facilities as long as they were equal. 2 years before Belton and Beulah, in 1950, my father decided Parker versus University of Delaware. In that case, Lewis Redding made his first appearance. He was a fearless African-American attorney who was bent on ending desegregation, not just in Delaware, but throughout the country. My father reluctantly concluded in Parker versus University of Delaware that he was bound by the Plessy decision. But he visited University of Delaware and Delaware State College, found the educational opportunities grossly unequal, and entered an injunction prohibiting the University of Delaware from considering race in the application process. Remarkably, there was no appeal from his decision. It should come as no surprise that the same framework would be applied in the Belton and Beulah decisions. Before deciding Belton and Beulah, my father gave what I think could be appropriately characterized as an incendiary speech to the Salesianism High School graduating class of 1951. In those remarks, he said, and I quote, "In my opinion, the most pressing domestic issue today in Delaware, and in fact the United States generally, is the so-called Negro white problem, more accurately called the American problem. Many of us would become fighting mad were we told that we did not really believe in the great principles of the Declaration of Independence and the Constitution of the United States. Yet I submit that too many of us talk out of both sides of our mouths at the same time on this important subject. How can we say that we deeply revere the principles of our Declaration and our Constitution, and yet refuse to recognize these principles when they are applied to the American Negro in a down-to-earth fashion? It does not take any particular moral courage to come out in favor of the great principles upon which our country was founded, but it takes real moral courage not only to say that those great principles apply to the Negro, but also to see that he in fact receives their benefits in his daily life. A person has real moral courage when, being in a position to make decisions or determine policies, he decides that the qualified Negro will be admitted to the School of Nursing, that the Negro, like the white, will receive a fair trial no matter what the public feeling may be, that every Catholic school, church, and institution shall be open to all Catholics, not at some distant future time when public opinion happens to coincide with Catholic moral teaching, but now. Are these requests of our business, governmental, and religious leaders too much to ask? I think not." Close quote. 1951. In Belton and Beulah, Lewis Redding once again brought cases challenging segregation in the Hockessin and Claymont schools. The testimony you heard today led my father to observe, in his opinion, quote, "Plaintiffs produced many expert witnesses in the fields of education, sociology, psychology, psychiatry, and anthropology. Their qualifications were fully established. No witness in opposition were produced. One of America's foremost psychiatrists testified that state-imposed school segregation produces in Negro children an unsolvable conflict which seriously interferes with the mental health of such children. He pointed out that state-enforced segregation is important because it is clear-cut and gives legal sanction to the differences of continuous duration. He also pointed out other factors which, viewed against the social background of the Delaware community, necessarily have the effect of causing the Negro child to feel that he is inferior because, in an indirect fashion, the state has said so. I conclude from the testimony that in our Delaware society, state-imposed segregation in education itself results in Negro children as a class receiving educational opportunities which are substantially inferior to those available to white children otherwise similarly situated. Nevertheless, I do not believe a lower court can reject a principle of the United States Constitution, which has been adopted by fair implication by the highest court of the land. I believe that separate but equal, that doctrine in education should be rejected. But I also believe that rejection must come from the United States Supreme Court. My father was unable to strike a fatal blow to segregation because of his required deference to the United States Supreme Court. So my father once again compared the educational opportunities of white and black schools, and unsurprisingly found that the black schools were grossly inferior to the white schools. And unlike many courts who let the state off the hook by allowing time to bring the black educational institutions up to the level of the white schools, my father ordered the immediate desegregation of the white schools. The aftermath is an important but not well-known part of history, which is why we're here today. The appeals in Brown versus Board of Education included the Delaware cases. In Brown, the United States Supreme Court unanimously overruled Plessy. Taking a cue from my father, the highest court in the land held that, quote, segregation in education itself results in Negro children as a class receiving educational opportunities which are substantially inferior to those available to white children. Right out of the mouth of Dr. Clark. The Delaware cases, as you've heard, were the only ones affirmed by the United States Supreme Court. My father said that the Belton and Beulah decisions were easy cases because he could not see how the Equal Protection Clause of the 14th Amendment could be read in any other way. To his comment that these were easy cases, I say, pshaw. Happy anniversary, 70th anniversary, Brown versus Board. And what great pride we should feel as a state for having played such an essential part in the decision. Court is now adjourned.
On the rise. And report state of Delaware. Everyone, there's a presence out in the hall. Appreciate your attendance.